Hello, everyone. We're delighted to be here today with you. For those of you who don't know me, my name is Erin Cho, and I'm a partner in our employee benefits practice from Washington, D.C., where I focus on ERISA's fiduciary rules. I'm happy to be joined by my partner, Maureen Gorman, who heads up our employee benefits practice from Palo Alto. Maureen focuses on employee benefits as well as executive compensation matters. And we are also delighted to be joined by our colleagues, Hillary August. Hillary practices from our Chicago office on a wide range of employee benefits and ERISA matters that affect plan sponsors. And last but certainly not least is my colleague, Joe Lifsix. Joe's practices also focuses on ERISA's fiduciary rules, as well as pension investment matters. So next slide, please. Today, we have about 90 minutes, and we are going to focus on 4 hot areas. And the first will be cybersecurity considerations for benefit plans. As many of you know, the Labor Department issued guidance in this area last spring. Next, we will be covering the very newly proposed rules on ESG investing and proxy voting. Next, Maureen is going to provide us some updates on the lifetime income disclosure rules. And Hillary is going to give us a summary of best practices on how to handle missing participant issues. So next slide, please. Great. So I'm going to start us off today with a discussion on cybersecurity. And as many of you have heard and are familiar with, retirement accounts have been for a number of years attractive targets for cyber-enabled fraud. And the reasons why are multiple. The first is plans probably hold, nearly $10 trillion in assets. So there's a lot of money there. And it is well known that plan participants generally check their retirement accounts less frequently than their other financial statements, such as banking, credit card, or other financial accounts. And so therefore, by the time a retirement account fraud has been detected, there may be some delay, therefore allowing, either for fraudster to get away with the crime. And so this is, another issue. There's also quite a bit of personal information that's available on the dark web. So, the folks can find out basic information about participants and their age and workplace and address and so forth. And also plans, because they permit electronic access to their funds and rely on outside service providers, it therefore permits more access points for breach. So next slide. So just want to give you a bit of backdrop here. Over the years, I have gotten calls from clients telling me that a participant in their 401k plan has lost its account assets. And, typically, historically, the amounts, have been small, and record keepers have been willing to as a courtesy matter, perhaps reimburse participants for their losses. But over time, these claims have gotten more frequent, the amounts of losses have mounted, and we have found that service providers naturally have become more resistant to reimbursing participants for their losses. So if this comes to your attention, the first thing you need to do, obviously, is make sure there's an investigation, because more times than not, it may not be because of a cyber-enabled fraud, but rather because of identity theft, or even I've had a situation of a disgruntled family member accessing a participant's account. Nonetheless, this has become an increasing problem, and there have been situations resulting in litigation. And there are 3 cases that have been in the news and have raised pretty important questions about the extent of responsibility. One is, what are the appropriate or best practices that plan sponsors as well as service providers should be maintaining in this area. And what are also the duties of plan sponsors to monitor the cyber practices of their service providers? So turn to the next slide, please. The first case that hit the news was a case of actually involving a law firm. And here the plan participant, due to, I think there was an email hack of the plan administrator's email account, and the perpetrators were able to dupe the bank account information and falsify that and put in requests which were essentially that wiped out the participant's account. And the defendants here, the plan administrator, filed immediately for a motion to dismiss, but the court sided with the participant at the motion to dismiss stage, holding that the service providers were fiduciaries and that the claims could proceed. So the takeaway from the Leventhal case is actually that cybersecurity claims are viable, at least at the motion to dismiss stage. So next slide, please. Right, so essentially the court rejected that there was no breach of fiduciary duties, and that there was no, essentially that the participant and the plan providers failed to comply with their duties of prudence and diligence, particularly when there were multiple withdrawal requests to distribute the funds to a different bank account. So the court essentially agreed with the plaintiffs that the defendants failed to implement basic procedures and safeguards. The next slide. The next case also involved actually a retired participant at Estee Lauder company. Basically, over the course of 2 months, there were 3 separate withdrawal requests, and essentially which wiped away the participant's retirement account. And unfortunately, the notification, there weren't any checks by the bank or the record keeper with respect to these changes in bank accounts. And the plaintiff actually didn't receive notice because notification to the plaintiff was sent actually over snail mail. And by the time the plaintiff had discovered these withdrawals, some time had passed, and it was therefore difficult to track the perpetrators. So when the plan sponsor and the record keeper refused to reimburse the plaintiff, the participant, she sued, and this did result in a settlement. But again, this case is again important because it again raised these similar issues as did the Leventhal case about what are exactly best practices and what protective mechanisms should service providers be adopting in this space. We could turn to the next slide. So turn to the next one, please. Great. So the Barnet case is actually still ongoing, and there as well, kind of a similar fact pattern. The participant lost money in its retirement account, and there was a lawsuit brought against the plan fiduciaries, the plan sponsor, as well as the record keeper. And the court 2 times is being litigated in the Northern District of Illinois, dismissed claims against the plan sponsor as well as the fiduciary committee on the grounds there was no evidence that they failed to monitor. However, the court has rejected the record keeper's arguments that it did not act as a fiduciary, and it has allowed those claims to proceed forward against the record keeper. Now, this is a pretty important case, I think, for the record keeping community, because historically record keepers have taken the position that they are not plan fiduciaries. and their administrative and other duties that they may have under the service provider agreements do not amount to fiduciary and exercise of fiduciary duties. So this is I think a pretty important case for us to watch. So if you could turn to the next slide, great. So against this backdrop, the litigation backdrop, as well as a report from the General Accounting Office urging the Labor Department to set forth clear standards for plan sponsors and administrators to protect participants from cyber theft. Last April, the Labor Department issued tripartite guidance for service providers, plan sponsors, as well as participants. So, so this basic, the DOL guidance for service providers, I think it's pretty important to review. It really does not depart, though, too much from guidance that has been issued by other regulators, such as the SEC. So I think that, from a service provider perspective, they can coordinate, they should be able to coordinate their efforts between the DOL guidance and guidance from other regulators. As many of you are aware, the SEC has also been pretty active in monitoring this space, as well as auditing and investigating service providers. At the end of August, the SEC sanctioned 8 broker-dealers, as well as registered investment advisory firms, for inadequate cybersecurity policies and procedures. So, mind turning to the next slide? Great. So the DOL guidance includes pretty important points for plan sponsors to keep in mind when they are hiring or in the process of contracting with service providers to their retirement plans. And it includes a list of items that really plan sponsors should consider when evaluating service providers. Do they use a third party to audit their cybersecurity policies and procedures? What are the provisions? How do they use and share information? What types of notification will they give to the plan sponsor in the event that there is a cyber breach? How do they comply with privacy laws, as well as does a service provider maintain a certain amount of insurance coverage? And I think that given the claims in this space, we think that at least $5 million is a decent place to start. So if we could turn to the next slide. The Labor Department also recognized that participants also have a role to play in this. And so there's tips for plan participants here, which are fairly common sense, but I do think that it's important for plan sponsors to either have training or provide also written guidance and reminders to plan participants in light of this Labor Department guidance. Next slide, please. Okay. So with all of this backdrop, there was in May, there was an executive order on cybersecurity. And I think just the point here is that this has really become a national priority on many levels, obviously not just for the retirement plan industry, but I think in all areas. So again, this has become at the national level, and we're also seeing that the cybersecurity questions are just becoming a normal part of DOL audits and investigations. So I think it's pretty important to the extent that plan sponsors have not reviewed their practices in this area. Really important to review to make sure that they follow the Labor Department guidance and these questions, diligence questions of service providers are being asked. So turn to the next slide. Right, so again, in light of the attention we're seeing from the Labor Department in this area, the takeaways for plan sponsors are that it's really important, again, to compare your service provider's program, ensure that they meet industry standards, ensure that they engage a third-party auditor, ask about prior security breaches, ask about the provider's insurance policies, hopefully that they do have insurance policies. Next slide. And also, include not, in your contracts, we have been including in a cyber provision really in all of our service provider contracts that really ensure that the service providers are making representations, that they do have protocols in place, that they do have, either, if they use a third party auditor. And also it's pretty important to check on limitations of liability clauses, and also include a notice provision whereby the service provider will be required to give you immediate and prompt notice when there is a breach. Here we go. So again, I think that, current contracts with service providers should be reviewed. And to the extent that they don't meet up to the DOL standards, you may want to consider amending those contracts at the next appropriate time. I think on a going forward basis, plan sponsors need to include perhaps a checklist of items that they are checking upon service providers. I think even though I've had experiences where service providers may push back on the provisions that we draft or include, it's really important that at least the plan sponsor, goes on record that it did ask these questions and did, really check these boxes in terms of diligencing their service providers, and that a record is kept with respect to the fact that these questions were asked. So again, I encourage, to do this as soon as possible. In all future RFPs, I think there really should be included a section on cybersecurity as well. So you want to please turn to the next slide? Great. So one note of ambiguity that the Labor Department still has not clarified is that in the guidance, they refer to, in many places, retirement plans, but in other areas, the guidance refers to ERISA covered plans. So therefore, it does raise a question as to whether health and welfare plans is also captured by the DOL guidance. And so, therefore, some coordination does need to happen between the tension with HIPAA's, privacy standards, along with the requirements under this guidance. And and as I mentioned before, again, educating plan participants regularly and giving them reminders of the importance of strong password use, updating personal contact information, and regularly monitoring their accounts is also pretty important. The next slide. Great. So I am going to, without further delay, unless there are any questions, I'm going to kick it over to Joe.
Okay, great. Thanks very much, Erin. So I am talking about the extremely new Department of Labor proposed regulation on ESG investing and proxy voting. It's only a couple weeks old, and even though this particular regulation is so new, it's got quite a long history. The Department of Labor has issued lots of guidance over the years on both ESG investing and proxy voting in the context of ERISA's fiduciary duties. And I've heard people call this regulatory ping pong, or just a constant shift in gloss and tenor in the way the Department of Labor has viewed these issues, depending on who has been in the White House at that time, with Democratic administrations generally favoring ESG investments and the use of proxy voting, the use of shareholder rights by ERISA plans, and Republican administrations generally, viewing ESG investment and proxy voting in a less favorable light. So with all that said, ERISA still requires that the economics of an investment are still the key factor, and that cannot be sacrificed. So everyone agrees that you cannot make an ESG investment that's a poor investment if it's even if it might have a good policy goal, or it's something which could do good to the world. Until 2020, all the guidance that the Department of Labor has issued was sub-regulatory. So it was in the form of field assistance bulletins and interpretive bulletins, and it was very easily changed by the next administration just by issuing a new piece of paper. But then in 2020, things changed a little bit, and we can go to the next slide. So in 2020, the Department of Labor issued an actual regulation on both ESG and proxy voting, and these came out right before President Trump left office. And the basic principle was the Department of Labor didn't say that you couldn't make ESG themed investments, but the general tone was that of skepticism regarding the use of ESG while making investment decisions. And there was a point of emphasis on those scenarios where plan shareholders, the plan's shareholder rights should not be exercised by the plan because of costs, or for the reason that maybe the particular proxy vote was not of importance to the plan. And like I said, that was right before President Trump left office. And when President Biden came in, it was very clearly a priority of the administration that these regulations be done away with. And President Biden issued 2 executive orders on these regulations. One of them being on his very first day in office, directing the Department of Labor to review these regulations, and then a later one stating that the Department of Labor should consider rescinding and replacing the regulations. And then in the interim, in March of 2021, the Department of Labor issued a non-enforcement policy of those Trump era regulations. And I'll just note that even though the Department of Labor is not enforcing those current regulations, that doesn't mean that a plan participant or beneficiary could not sue to enforce those regulations, because they are technically still current. And we can go to the next slide. So what exactly did those 2020 regulations say before Trump left office? So the way the regulation was originally proposed, it singled out ESG investing, and it referred to ESG investing as requiring additional hurdles to go through for a plan fiduciary to consider ESG in making plan investments. There was a lot of blowback by both plan sponsors and investment managers who were not happy with that guidance. and the final rule was much more scaled back, and it didn't actually use the term ESG at all. It referred to pecuniary and non-pecuniary factors. So basically, the plan fiduciaries had to focus solely on the economics and the risk return of the investment. The use of non-pecuniary factors were extremely limited. So, let's say something's a good policy goal, or maybe it's even something which plan participants are in favor of generally. Let's say it's a union pension plan, and the pension plan wants to invest in projects that use union labor. This was not allowed by the 2020 regulations unless there was a tie, in the event of a tie, when the plan fiduciary was considering two different investments that the plan fiduciary could not distinguish between based on pecuniary factors. And the Department of Labor said this was a very high threshold. So it kind of expressed skepticism as to whether there even could be a scenario where it envisions a tie where you couldn't make any distinguishing features based on the pecuniary factors, but it did allow the use of non-pecuniary factors in those situations, provided that the plan fiduciary documents its use of those factors. Finally, there was also a prohibition on selecting QDIA if the investment options, objectives, goals, or principal investment strategies considered non-pecuniary factors, and that was even if it was otherwise a good investment option based purely on the economics. The Department of Labor said that since a QDIA it's a default investment option for plan participants, there needed to be extra guardrails there to make sure that the plan fiduciaries didn't select the investment option based on non-pecuniary factors. And we can go to the next slide. So what do these new proposed regulations look like? So they are, as you'd expect, more welcoming of the use of ESG as a consideration. But that being said, the principle ERISA, the ERISA principle of economics still being the key factor, that's still true. So fiduciaries still can't choose investments based on the policy preferences of the participants or its own policy preferences if it doesn't make economic sense. What the new proposed regulations do specify is that climate change and other ESG factors may often be material economic considerations. So the proposed regulation provides certain examples of material economic considerations that are driven by ESG. So it talks about climate change. So both the direct effects of climate change on a company, and then also the requirements that the government might impose on a company associated with climate change, governance factors, so things like board composition, accountability, and transparency, and then workforce practices, things like diversity, retention, and training practices. So the Department of Labor is stating that these are economic considerations and may often be material to an economic analysis. Next slide. In terms of collateral ESG factors, so the non-economic ESG factors that are just policy preferences. The new proposal is more permissive. The factors can be used as a tiebreaker, and there's a more permissive standard for when a tie occurs. Investments, if they, the term that the Department of Labor uses, if they equally serve as the financial interests of the plan over an appropriate time horizon, that will be considered a tie, where you can then start to use the collateral ESG factors. And so, you know, in other words, investments can be economically distinguishable. There can be different economic features to the investments, but if at the end of the day that they're both equally appropriate for the plan's investment portfolio, you can then start using those collateral factors. And the Department of Labor requested comments on whether there should be certain kinds of collateral factors that can be used. But as of now in the proposal, it's left open, and any kind of collateral factor can be used in the event of a tie. And they also got rid of the documentation requirement that was in the current Trump rule. Next slide, please. There are additional restrictions around the use of collateral factors as a tiebreaker when you're selecting designated investment options in a participant-directed plan, like a 401k plan. And the restriction there is the nature of the collateral factors that are used to select the investment option need to be prominently displayed. And the place for that disclosure isn't specified, but in the preamble, the Department of Labor states that the 404A5 required disclosure is probably the natural place to put this. And the thinking there is the plan participants who may not share a policy preference, or you know, don't share the same views as the plan fiduciary, knows why the particular investment option was selected, and can choose to refrain from investing in this investment option on that basis. Finally, the new proposal gets rid of the rule that a QDIA cannot be chosen just because its you know, primary goals include the consideration of collateral ESG factors, as long as the investment option is chosen, you know, it otherwise makes that economic sense and is financially prudent and meets the QDIA regulations. Next slide, please. So that's it with ESG. The proxy voting portion of the proposed regulation, things are a little bit less different, but there still are some significant differences from the 2020 Trump era regulations. So
go into the proxy rules, maybe just one, I think, should we touch on one area I think that's been on concern, you know, top of mind, I think, for clients, is that during the Trump administration, the rule combined with dozens of audits and investigations of plan sponsors that included ESG funds on their platform. Our ERISA litigators were also defending plan sponsors from claims that from really, you know, from the plaintiff's bar that claims that they included too many ESG funds, or they imprudently offered ESG funds. So I think the status, what happened is that there has been a chilling effect of adding ESG funds. So I think one of the concerns of plans fiduciary committees is, do they now need to reconsider and offer ESG funds, or, you know, or will they be at risk of perhaps getting sued by the ever creative plaintiffs bar here?
Yeah, thanks for bringing that, Baron. So I was going to talk about this a little bit with respect to the takeaways, but I think the Department of Labor is clearly indicating a more favorable view of ESG investments, and I think at a minimum, depending on how the final regulations shake out, because it obviously it can change based on the comments that the DOL receives. There is, I think, definitely some risk to not including the use of ESG from an economic perspective as part of a plan fiduciary's regular analysis of investment options. So if a plan fiduciary is considering investment in a coal company and it doesn't think about what could happen from in terms of regulations and other PR issues, things like that, I think that it's definitely could lead to litigation risk and possibly the DOL getting involved.
Yeah, that's right. I mean, I think this whole ping-ponging between administrations is exhausting for folks. And maybe one solution to consider as to whether, if your plan does offer a brokerage window, whether you offer ESG funds through that brokerage window. Yep.
Thanks. Yeah, so in terms of proxy voting, I think the Department of Labor really highlighted its longstanding view, and this is not changed, is that ERISA's fiduciary duties extend not only to the management of a plan's assets, but also the plan's proxies and other shareholder rights pertinent to those assets. And what the Department of Labor emphasized was that proxies should generally be voted upon, unless doing so would not be in the plan's best interest. So, for example, there's a lot of costs involved in exercising those rights, and it's not a material issue, then a plan would refrain from exercising shareholder rights, but generally their view is the rights should be exercised. Importantly, the proposal removes language from the 2020 Trump era rule that fiduciaries need not vote every proxy, and that shouldn't be misconstrued, and because the Department of Labor in the preamble explains this is still technically true. It doesn't mean to suggest that every single proxy should be voted upon, but it thought that this language was misleading in that plan fiduciaries were interpreting this as a directive not to vote. Another significant difference from the Trump era regulations is that there was a specific requirement that plan fiduciaries document its use of plan shareholder rights and its exercise of proxy voting on behalf of the plan, and that is now eliminated. Next slide, please. And I should also note in terms of the documentation right, the Department of Labor, it does state that there is a general prudence rule that's applicable to ERISA fiduciaries, and that depending on the exact rights that are being exercised, that itself might lead a prudent fiduciary to documenting its exercise of those rights, but there is no specific documentation right requirement with respect to proxy voting. In terms of what a plan fiduciary should consider in determining whether it's going to exercise shareholder rights or vote a proxy, and how it should vote those proxies or exercise those rights. The regulation lays out a number of factors that a fiduciary should consider, and this is largely in line with the current 2020 regulation. So plan fiduciary needs to act solely in accordance with the economic interests of participants and beneficiaries. It cannot subordinate the participants and beneficiaries' financial interests to any other objective, like their own policy preferences. It needs to consider the relevant costs involved in exercising shareholder rights on behalf of the plan. It needs to evaluate the material facts that form the basis for the proxy vote or exercise of shareholder rights. And it needs to exercise prudence and diligence in selecting and monitoring service providers that exercise or otherwise assist with the exercise of shareholder rights. This last one in particular, the 2020 current regulation was very concerned with the way that certain plan fiduciaries would just follow along the lead of the leading proxy advisory firms, like ISS and Glass Lewis. And there actually was specific language in the 2020 regulation stating that a plan fiduciary shouldn't just go along with what its proxy advisors say. The current regulation gets rid of that language, but the preamble clarifies that a plan fiduciary still needs to exercise the prudence and diligence in monitoring proxy advisor, and it's just incorporated into this specific requirement. Next slide, please. Another minor or possibly significant difference from the current 2020 regulations is that relating to the guidelines that a plan fiduciary can use to assist in deciding which proxies to vote. So similar to the current rule, the proposal still requires any guidelines used be prudently designed to provide benefits to participants and beneficiaries and defray reasonable administrative expenses. But there are no sample safe harbor policies that, unlike the current rule, which provides specific policies that are safe harbors. It's just here the Department of Labor thought that the current safe harbor policies were misleading and possibly ineffective. So it just revised to a purely principles-based approach. There is a requirement that fiduciaries review such policies periodically. Prior guidance indicated approximately every 2 years. And notwithstanding a given policy or guideline, a fiduciary can always override and decide to vote or not vote a given proxy if it believes doing so would be in the plan's best interests. Next slide, please. This again is a longstanding ERISA principle that for pooled investment vehicles that are subject to ERISA, like a plan asset fund that has multiple ERISA investors, the manager of that vehicle needs to reconcile conflicting voting policies amongst the different ERISA investors. So with respect to proxies, a manager can vote in proportion to each ERISA investor's respective interest in the vehicle. Alternatively, and what's typically done is that the manager can require the plan to review and approve of the manager's own policy prior to the ERISA plan deciding to invest in the investment vehicle. Next slide, please. So takeaways, the Department of Labor has clearly shifted towards viewing ESG investing in a more favorable light. So as I mentioned before, if a fiduciary is not currently incorporating ESG into its current economic analysis, it should consider taking steps to do so. We'll see what the final regulation, how it shakes out, depending on the kind of comments that the DOL receives. But it clearly is signaling that the DOL views ESG with much more importance than the prior administration did. That being said, economics still remain key. You can't just ignore economic considerations in favor of policy preferences, whether that of the fiduciary or the plan participants. And then in general, proxies should generally be voted upon unless there's a determination that it's not in the plan's best interests. And comments on the proposal are due December 13th, 2021, and we'll see what the final regulation looks like.
So today I'm going to be talking about some recent DOL guidance on handling missing participant issues. When we talk about missing participants, that's kind of a shorthand for talking about a participant or a beneficiary or an alternate payee who is due a benefit from a retirement plan, but who can't be located. And this is a situation that retirement plan administrators and benefits attorneys find themselves in all too often, and really can be exasperating and also a little confusing, because you wouldn't think it would be so hard to deliver money to people who are entitled to it. But it is a situation that comes up quite a bit. So in an attempt to alleviate some of these issues and to help ensure that participants and their beneficiaries are getting the benefits that they're due and that they expected to get under retirement plans, the DOL in January issued 3 related pieces of guidance. One is a set of best practices for pension plans that describe steps that fiduciaries can take to reduce missing participant issues. The second is a compliance assistance release that outlines the investigative approach that guides the DOL's regional offices under its terminated vested participant project. And the third is a field assistance bulletin that authorizes fiduciaries of terminating defined contribution plans to transfer participants' account balances, if those participants are missing, to a program that the PBGC has as a matter of temporary enforcement policy. Next slide, please. So this isn't the first time that we have received some sort of agency guidance on missing participant issues. For example, the PBGC, as I noted, has its own program where it will accept benefits on behalf of a missing participant in the context of a terminating plan. And this program initially started just for defined benefit plans, and then in 2017 expanded to defined contribution plans. In addition, the DOL itself has issued guidance on how to handle these missing participant issues. Generally, the guidance that has been issued before January has been in the context of terminating plans. And in its previous guidance, the DOL has done things like lay out certain search methods it viewed as being appropriate and provided a safe harbor for what a fiduciary could do with a participant's account balance if the participant was missing in the case of a terminating plan, such as rolling the benefit over to an IRA. Next slide, please. But over the past several years, the DOL has been focusing more and more on this missing participant issue. This initiative started in the DOL's Philadelphia regional office during President Obama's administration, and then it started spreading to other offices. And this turned into the Department of Labor's Terminated Vested Participant Project, which was essentially looking at how plans were dealing with these missing participant issues in the context of defined benefit plans. And this also led the DOL to conduct its own searches for participants. So the DOL drew on its experience from the project and from its searches to issue these new pieces of guidance in January. Next slide, please. The first piece of guidance is the best practices document. And the best practices document generally describes various practices that the Department of Labor thinks that retirement plans should be taking or should consider taking as steps to help reduce these missing participant issues and to ensure that participants do receive their benefits. The DOL noted in the guidance that not all of its suggested practices to locate missing participants are appropriate for every plan. So that means that fiduciaries need to consider what practices would yield the best results, taking into account their participant population. But fiduciaries can also take into account on a case-by-case basis the relative cost of search efforts in comparison to a missing participant's account balance. The document itself also doesn't have the force and effect of law, and it's not meant to obligate plan fiduciaries to take any specific actions to locate missing participants. So determining which actions to take of the DOL's suggestions involves a consideration of ERISA's fiduciary duties, namely the duty to act with the care, skill, prudence, and diligence that another reasonable fiduciary would use under the circumstances. Next slide, please. The best practices document starts by explaining that in the DOL's experience, it has seen that there are a number of red flags that may serve as warnings or indicators that a plan has a missing participant issue, even if they don't know it yet. So some of these red flags are more than a small number of missing or non-responsive participants, or more than a small number of terminated participants who are vested in their account balance and who have reached their normal retirement age but haven't started receiving their benefits yet. Other red flags are if there is missing or inaccurate or incomplete contact information or census data, or if there is a large usage of dummy information in the census. So for example, if you have a situation where the census is filled with John Doe instead of an actual beneficiary name, or all zeros for a social security number. Other red flags are absences of sound policies and procedures for what the plan does if it gets returned mail or an uncashed check. I think some key takeaways here are: one, audit census information on a regular basis. And this is not necessarily just something the plan sponsor will be doing, but given that in the context of many plans, especially large plans, you're working with a record keeper to do things like update the census information and make sure everything is up to date. There's some proactive steps you can take here. One would be looking at your record keeper agreement to determine if the record keeper itself is auditing census information. And another would be talking to the record keeper about the steps that they're taking if they receive returned mails or what they do to make sure that address information is up to date. Next slide, please. The DOL in the best practices document then transitions into talking about the importance of maintaining accurate census information. And so in addition to just auditing the census information for red flags, the DOL suggests some of the following methods. One would be contacting participants and beneficiaries to confirm or update their contact information. Another would be making it easy for participants and beneficiaries to update their information, such as by including contact information change requests in plan communications and allowing participants to update their information on the plan website. The DOL also suggests that one time in particular, when you want to pay particular attention to missing participant issues, is in the context of a major corporate event. So that's something like a merger or acquisition or a change of record keepers, because that could be a time that participant contact information could get lost in the shuffle. I think key takeaways here, one is just remember that you're including contact change requests, talking to your record keeper to see when and how often they might be including any sort of contact change requests in plan communications. And something else that came out of the DOL's guidance is in asking for contact information, you might want to ask not just for the regular contact information you would think of, name, phone number, address, email address, but also you could consider asking for social media information. And I think in the context of especially a younger participant population, this could be especially helpful. We've seen with the pandemic, people are often leaving their homes to go stay with family or friends, but probably their Instagram and their Twitter handles are not changing. So that might be an effective tactic here. Next slide, please. The next section of the DOL's document is advice on communicating effectively with plan participants to make sure that they are updating their contact information, doing things like using plain language, offering non-English assistance, also stating upfront and prominently what correspondence is about. So the DOL is envisioning a situation where if company A acquires company B, and in the process of doing so, company B's retirement plan merges into company A's retirement plan. And so then the name of the plan that people participate in is changing. Well, if you have people who still have account balances in company B's plan that merges into company A's plan, but they are no longer with the company, they might not be aware of this corporate transition that went on. So one suggestion would be to note on correspondence the name of company B's plan, because people will be more familiar with that. Again, some takeaways here. A lot of this guidance involves working closely with your record keeper or service provider that is operating the website or any toll-free telephone number, and also just thinking about what sorts of, what aspects you need based on your participant population. If you have a participant population that is largely non-English speaking, making sure your record keeper has those capabilities. Next slide, please. The heart of the issue then is really what to do when a participant is missing or unresponsive. And the DOL noted, again, that not all of these practices are appropriate for every plan. So plan fiduciaries should consider what practices will yield the best results. Some of the steps that the DOL suggests are drawing on information from related plans. So if a participant participated in both a retirement plan and also a health plan, checking with the fiduciaries of the healthcare plan to see what if the participant's contact information had changed. The DOL also suggests checking with designated beneficiaries or a participant's emergency contacts, making use of free online search tools like search engines and social media, and also using proprietary search tools, using commercial locator services or credit reporting agencies, or reviewing public records, or attempting to contact the participant through certified mail. And then if the participant really can't be found, the DOL suggests you might want to search obituaries or death records so that you could direct communications to the beneficiary if appropriate. And the DOL also suggests registering missing participants on public and private pension registries. Some takeaways here are that a lot of what the DOL has suggested involves talking to a third party to find the beneficiary's contact information, asking the fiduciary of another plan, contacting the emergency contact person for the participant. And so before, the DOL acknowledged that there may be some privacy implications in doing so. So before taking some of these steps, you might want to consider talking to privacy counsel to see if they have any thoughts on this. Next slide, please. The last piece of the DOL's best practices is on documenting policies and procedures that the plan is taking to ensure that they are clear, and also documenting key decisions and actions that the plan takes in order to implement those policies and procedures. So, for example, documenting the steps taken to locate a missing participant, You also want to make sure that a record keeper is doing what you have agreed the record keeper will do in the context of a missing participant, and look to see what might be a shortcoming in the record keeper's process for finding missing participants or handling issues like an uncashed check. I think some key types of policies that you might want to consider documenting could include guidance for handling undeliverable or returned mail, what happens, who processes it, also any procedures for conducting plan audits, and then just thinking about what steps would be taken to locate missing participants and how to decide what steps to take. And another really key point here is just making sure to document everything that is done when you're looking for missing participants. Procedural prudence is a big part of ERISA, very important. And so being able to show the process that you undertake is really important. Next slide, please. I'll next go into the other two pieces of guidance the DOL issued in January. The first is an internal DOL memo that the agency published to help plan fiduciaries understand what could lead the Department of Labor to conduct one of these terminated vested participant audits of a defined benefit plan and what to expect when it does. I think it's helpful to read this guidance in light of the best practices document, because when you do that, you can see how the things that the Department of Labor is saying in this memo that it's going to look for really lines up with what the Department of Labor is encouraging plan fiduciaries to do in the best practices document. The memo also explains reasons that the Department of Labor might open an investigation in the first place. One might be a situation where a plan administrator reports on its annual report, Form 5500, that it has a large number of retired or terminated vested participants entitled to future benefits. Another would be if the plan sponsor is facing bankruptcy or involved in another corporate transaction. In terms of what the Department of Labor is looking for, its goal is to determine the scope of any potential issue. And so to do that, might want to ask for documents like plan documents, summary plan descriptions, census records, copies of policies and procedures, and actuarial reports. In terms of the actual process of the audit, the Department of Labor said it will first send an opening letter asking for general information about the plan. Once it has a chance to examine that, then it will send a targeted follow-up letter. And the Department of Labor says in the memo that it will begin by asking for voluntary cooperation. But if a plan isn't forthcoming, then the Department of Labor could obtain a subpoena if necessary. The DOL also said it's on the lookout for errors like systemic errors in record keeping or inadequate procedures for things like identifying, locating, and contacting participants, and also generally for the red flags that I discussed in the best practices document. And then to close cases, the memo instructs investigators to engage in discussions with plan fiduciaries about how they could remedy any problems. The DOL may issue a voluntary compliance letter to address potential ERISA violations, though it generally won't cite individual plan fiduciaries with specific violations, so long as the fiduciary engages in appropriate remedies to correct any flaws. Next slide, please. The final piece of guidance is this field assistance bulletin in which the Department of Labor announced a temporary enforcement policy, which is that it won't pursue violations of Section 404A of ERISA against fiduciaries of terminating defined contribution plans for transferring a missing participant's account balance over to the PBGC under the PBGC's missing participant program, so long as the fiduciary meets a number of conditions. They act in good faith, they comply with this bulletin, and they generally comply with ERISA. So the reason for this guidance is that even though the PBGC opened this program to defined contribution plans in 2017, the DOL had not yet issued this formal guidance approving it. Some notes of caution. First, this is just a temporary enforcement policy, although the DOL has suggested that it might amend a safe harbor to include these transfers to the PBGC program. And second, the DOL cautioned that this would not preclude it from pursuing violations of ERISA for a failure to diligently search for a missing participant or maintain adequate plan records before transferring the balance over to the PBGC. And with that, I will turn it over to Maureen.
Thanks, Hillary. In July of 2021, the DOL issued FAQs that clarify the deadlines for the provision of the new lifetime income disclosure illustrations required by the Secure Act. And before we talk about the FAQs, I'd like to review a little background on this new lifetime income illustration requirement, because it is something that plan administrators will be dealing with for the first time this year. By way of background, as I think everyone probably knows, Section 105 of ERISA requires plan administrators of individual account plans to provide benefit statements at least annually to participants. And if you have a participant-directed plan, the benefit statements have to be provided at least quarterly. Now, a long-running concern has been that for the average plan participant, if you tell them the dollar balance of their account in one of these benefit statements, they really have no way of translating that or conceptualizing the retirement income that particular account balance is going to be able to fund for them when they retire. And in particular, you know, for some people, if they see an account balance of $100,000, that looks like a huge amount of money to them. And I think they don't really realize that that will only fund a very small retirement income when they ultimately terminate employment. So this has been a concern of the Department of Labor. And in 2013, the DOL issued an advance notice of proposed rulemaking in which it indicated that it was considering issuing a rule that would require lifetime income illustrations in benefit statements. And the ANPR described a framework for doing this, various actuarial and demographic assumptions that would have to be made in calculating the lifetime income disclosure. The rule was never proposed, but I wanted to mention it here because when we get to the FAQs, I will bring it up again by way of contrast with the new rules. Next slide, please. The Secure Act, enacted in 2019, actually did create a new requirement that plan administrators of defined contribution plans include in their benefit statement a lifetime income disclosure. And under that act, the lifetime income illustrations have to be done for two types of annuities: a qualified joint and survivor annuity and a single life annuity that are each actuarially equivalent to the participant's total account balance. And those lifetime income streams are to be calculated based on assumptions prescribed by the Department of Labor. Next slide, please. In September of 2020, the DOL issued an interim final rule that provides the elements for meeting the new lifetime income disclosure requirements. And according to the DOL, that rule is effective on September 18, 2021, and applies to pension statements furnished after such dates. So we are now in the compliance period. We've passed September 18, 2021, and employers and plan administrators need to begin issuing these lifetime income illustrations in their pension benefit statements. Advanced slide, please. Now, as probably everyone's familiar with, when you have an account balance and you want to translate it into an annuity, you need to make certain demographic and actuarial assumptions. And the DOL interim final rule prescribes those assumptions, and you have to comply with these. First of all, you start with the account balance, the value on the last day of the period for which you're issuing the statement. So if you're issuing the statement for 2021, you look at the value of the participant's account balance on December 31 of 2021, and you assume on that date that the individual is 67. And then you have to calculate the single life annuity and the qualified joint and survivor annuity that value, that account balance value, could fund for a person who was age 67 on that date. Each participant is assumed to be married. So you're going to end up doing a single life annuity and a qualified joint and survivor annuity illustration for each participant without regard to whether they're actually married. The QJSA is calculated as a 100% QJSA, and the spouse is deemed to be the same age as the participant. The interest rate assumed is a 10-year, the rate on 10-year treasuries, essentially in the last month of the period for which the benefit statement relates. So it would be the first business day of December of 2021 if you were issuing a statement for 2021. You know, that interest rate struck me as low, but in its preamble to the rule, the DOL explains that it was trying to choose a rate that it thought would approximate what an insurance company would use in pricing an annuity. The interesting thing is, and this is just a very much a side note, but there is a lot of litigation right now on actuarial assumptions used in defined benefit plans to convert single life annuities to joint and survivor annuities. And some of the debate centers around interest rates, although more often mortality tables, but the experts do battle it out as to what interest rates should be used. And so it'd be interesting to see if they make use of this IFR as ammunition in those debates. The mortality table prescribed is the mortality table under Code Section 417E. And there was also some interesting discussion in the preamble as to why DOL went with that mortality table. As I think probably everybody knows, normally in a plan, when you're calculating a participant's benefit, for example, in a defined benefit plan, you have to use a unisex mortality table. But if you're buying an annuity on the commercial insurance market, insurers may use a gender distinct mortality tables. And so there was a bit of a debate about which to go with. DOL ended up going with the 417E table, which is of course a unisex table. And their reasoning was it saved plan administrators the burden of finding out the gender of the participant and the gender of the beneficiary, which you would have to know if you were going to apply gender distinct tables. Advance the slide, please. This is just a picture of what the disclosure might look like. It's provided in the rule. You have the account balance. You have a monthly amount for the single life annuity and a monthly amount for the JNS annuity. Advanced slide, please. So it's important that these lifetime income illustrations be accompanied by appropriate explanations of the assumptions, because again, actuarial assumptions are never perfectly realized. And in fact, we can absolutely expect that any numbers that are provided to participants are going to be different than what they actually experience when they retire. And so it's very important that people have an explanation that these projections are based on actuarial assumptions and a discussion of what that means. The interim final rule includes model language that can be used to satisfy the explanation. And while the explanations are required, the use of the model language is optional, but I think invariably plan administrators will use the model, and that's because of certain limitation of liability considerations. Advance the slide, please. Congress understood that plan administrators, fiduciaries, plan sponsors were going to be very nervous about giving participants lifetime income illustrations when, as I've mentioned, they are likely to be very different than what the individual actually experiences when they retired. And given the plethora of ERISA litigation, we can expect that there would be ERISA litigation about the fact that, hey, the retirement income I'm getting doesn't really match those old projections I was getting 10 years ago. And so Congress built into Section 105 of ERISA a limitation on liability. Plan fiduciary sponsors and any other person involved in the generation of these statements shall not have liability by reason of the provision of those statements, as long as they're derived in accordance with the DOL assumptions and rules, and they include explanations that are contained in the model income disclosure provided by DOL. So compliance with the rule is critical, and the use of the model is important if you want to obtain that limitation of liability. Advanced slide, please. There are other special rules for the situation where a 401k plan, for example, has entered into a group annuity contract already, and when participants leave, they can purchase an annuity under that group annuity contract. There, your your disclosure really is going to use the terms in the contract. There's also a product called deferred income annuities, and these tend to be in-plan accumulation annuities, where participants make contributions to the plan and they're buying units in an annuity during the accumulation phase. And then those annuities are not scheduled to commence till sometime way in the future, frequently when the person's 85. There's also special disclosure rules for those DIAs. But I think the most important point I want to make here is that there's no model for this disclosure. And according to the DOL, the relief from liability rule does not apply to those products. So kind of an important thing to bear in mind. Advanced slide, please. The new FAQs. So as I noted above, the new rules, the new lifetime income rules, apply to benefit statements issued more than 12 months after the DOL issues its rules. So in this case, since the DOL came out with the rule in September of 2020, it became effective September 18, 2021, and it provides that it applies to pension benefit statements issued after such date. This, however, left commentators with numerous questions regarding the specifics of the effective date. For example, if you have a plan that has to provide quarterly statements, in which quarter do you have to provide the lifetime income enclosure for the first time? Advanced slide, please. The FAQs provide clarification on this. With respect to participant-directed plans, which have to deliver the benefit statements quarterly, they're required to comply with the IFR on a benefit statement that's issued no later than the benefit statement for the second quarter of 2022. I'm going to try to collapse some of this verbiage. Essentially, you have to, if you're issuing quarterly benefit statements, you've got to include lifetime income illustrations in at least one of them, and the latest one you can do it is the statement for the second calendar quarter and ending in 2022. So in other words, ending June 30th of 2022. DOL had previously issued guidance that for those quarterly statements, you have until 45 days after the end of the quarter to issue the benefit statement. So that'll be the ultimate deadline. The FAQs note that whether a plan delays its first lifetime income illustration to the fullest extent possible is going to depend on what makes sense for the plan based on its particular circumstances and its current distribution cycle for benefit statements. Next slide, please. For individual account plans that aren't participant directed and are just providing benefit statements once a year, the lifetime income illustration has to be provided on the benefit statement for the first plan year ending on or after September 19, 2021. So for calendar year plans, that means you need to include a lifetime income illustration in your benefit statement for 2021 for this year. Again, guidance previously issued by the DOL gives us a nice extended deadline for the actual delivery, even though you're including those illustrations in the benefit statement for 2021, you don't have to deliver that benefit statement until the due date for the Form 5500, which would be October 15 of 2022 in the case, again, in the case of calendar year plans. Advanced slide, please. Lingering questions, even left open by the FAQ. Well, as I talked about a little bit earlier, back in 2013, before the Secure Act was passed, the DOL issued that advance notice of proposed rulemaking, announcing that it was considering issuing a rule requiring lifetime income disclosure. And that ANPR required a number of illustrations, but significantly, one of those required illustrations is that you take the participant account balance and actually project it to age 65. So that would include earnings and projected contributions and so forth. And then you take that projected account at 65 and convert it into a single life and a QJSA annuity for participants. And so the illustrations would be based on a projected account. This differs in a number of ways from the new IFR, and commentators have noted that some employers and TPAs were already providing lifetime income illustrations in their benefit statements, and they were doing it along the lines of that advance notice of proposed rulemaking. And this was kind of a big deal. They geared their software and their IT and their forms all to conform to the ANPR framework. And so they have asked the Department of Labor if couldn't they just stick to those illustrations that they were doing under that old rule that never got proposed, and would that fulfill the requirements of the new interim final rule that requires a whole different calculation for lifetime income illustrations? And DOL's response was that, well, the IFR allows you to include both the IFR illustrations as well as additional lifetime income illustrations. So you can include the ones you've been doing for the ANPR, but it appears that that's not enough standing alone. You couldn't just use the ANPR illustrations. You've got to do the IFRs as well. And so it's, I think it means that everybody's going to have to do at least the IFR illustrations, and then they can keep their old ANPRs if they want. Advanced slide, please. As I mentioned, the current guidance is only an interim final rule. And although it prescribes all the demographic and actuarial assumptions that you need to do these illustrations, there's a lot of discussion in the preamble about how the DOL considered a number of alternatives, and they're open to comments on whether alternatives should be used. And there's been concern that if the DOL issues a final rule, that it might impose requirements that are either in addition to or are inconsistent with those in the IFR. And again, this is it's a problem because of all the IT that has to be generated to do these sorts of illustrations and to program everything properly. And so employers and third-party administrators have been worried that depending on the timing of the final rule, they might not have sufficient time to comply. The DOL gave us a little bit of cold comfort in those FAQs. What they do provide is that the DOL is going to issue another rule. They're going to issue a final rule as soon as practicable based on feedback they receive. And the DOL notes that they appreciate commentators' concerns about the burdens and challenges that could arise if the final rule differs materially from that interim final rule, but doesn't give employers sufficient time to accommodate any changes. So they're sort of saying, we feel your pain, but they didn't come out and say, and we'll definitely give you an adequate transition period. Hopefully, however, that's what they meant, and that's what we'll see. That is the conclusion of lifetime income disclosure. Also on the slide is a QR code. Please scan the code to fill out a brief evaluation survey, or click on the hyperlink, which we have included in chat. We would appreciate if you could complete the survey so that we may continue to provide thought-provoking comment. So do we have questions?
Yes, I think, Maureen, there's one question in the Q&A. I think it's directed to you. A clarification as to whether the disclosure should be part of the account statement, or the disclosure can be a standalone and not included in or with the account statement.
Sure. And in the model disclosure that the DOL issued, and this is really the model of the explanation of the actuarial assumptions, they've said that you can intersperse the explanation of the assumptions with your normal benefit statement, or you can provide it as a completely standalone model disclosure. If we don't have other questions, I have one for you, Erin. Sure. You mentioned in your cybersecurity presentation that plan sponsors and administrators should consider inquiring about the insurance that a vendor has for cybersecurity. And I'm wondering what reaction you're getting in terms of whether they in fact carry the insurance, what the amount of coverage is. Are they open to giving reps on the fact that they have insurance coverage? What are you seeing in the market?
I think the majority of at least advisors, investment managers, and so for the big players are willing to give a representation with respect to their insurance. And depending upon the service provider, for example, if it's an investment advisor or manager, we may start with 5 million. And I think the vast majority of them are able to give that representation. In some cases, the amount they may have may be lower, and so they may, they may give a rep on the lower amount. And in a maybe in one or two situations I've had so far, they resisted on giving a representation, but they were willing to have a conversation with us with respect to their insurance, and we noted and documented that conversation. But I'm really not finding, honestly, too much resistance in the service provider community with respect to cyber liability insurance representations, or a representation with respect to their compliance practices. There may be some negotiation about the exact wording of it, but I'm really not right now. People seem to really understand the importance of this, particularly for plan fiduciaries.
That's terrific. And as you point out, even if a vendor is resistant to it, it's important probably to document that the fiduciaries asked about it and explored that point.
That's right. That's right.
Okay, well, that wraps up today's program. And on behalf of Mayor Brown and my colleagues, thank you for your time. I hope you found this program useful.